Good morning, everyone. We will get started in about 30 seconds, just letting some other folks being admitted in. Okay. Good morning, everyone, and welcome to our webinar, Knowing Your Rights, Accessing College Tuition Sponsorship through New Jersey's Vocational Rehabilitation Agencies. Today's presenters, my name is Denise Lugo Fowler, and I'll be facilitating this webinar, but our presenters today are Stacy Bussell, our managing attorney of our adult practice group, and Susan Head, our senior advocate and program coordinator of our client assistance program. Disability Rights New Jersey is the designated protection and advocacy agency for New Jersey, and we are a nonprofit organization that operates under federal law to advocate for and advance the human, civil, and legal rights of New Jerseyans with disabilities. So a little bit of housekeeping here. This webinar is being recorded, and the presentation and the recording will be shared with the registrants as well as posted on our website. All the audio and video will be muted, and if you have any questions, please use the chat box. We will spend a little bit of time at the end with Q&A, and you can use the chat box also for any questions about accessibility. And you can add any subtitles to your screen. Just click on More, Show Subtitles. So before we begin with the substance of this webinar, a quick note that the information provided is for informational purposes only and does not constitute legal advice. We also have tried to use language that is person-centered and affirms the person with a disability's rights, but we recognize that the disability community has varied preferences on terminology. And lastly, this area law uses a lot of acronyms. We do our best to use the entire phrase along with the acronym, but we will use several acronyms consistently throughout the webinar. For example, DVRS for the Division of Vocational Rehabilitation Services, CBVI for the Commission for the Blind and Visually Impaired, and VR for Vocational Rehabilitation. So now I will turn it over to Stacy and Susan to begin.
Hi, everyone. Good morning. Thank you so much, Denise. Again, my name is Stacy Bussell. I'm the managing attorney of our adult practice group at Disability Rights New Jersey. And before we begin the content of the webinar, I'd like to review our learning objectives for today. One, we will begin with an overview of vocational rehabilitation, or VR basics, with a high-level focus on the Rehabilitation Act as amended by the Workforce Innovation and Opportunities Act, or WIOA. We will then have an in-depth discussion of the federal requirements for VR agencies to provide financial sponsorship of college and graduate school. 3, I will then turn the presentation over to Susan, who will talk about New Jersey's VR agency policies and procedures and graduate school financial sponsorship. And finally, we will finish up with a discussion of VR client due process rights, including the right to written notice and an opportunity for an impartial hearing called a fair hearing in New Jersey. At the end, as Denise mentioned, we will open up for a Q&A. Next slide, please. The Vocational Rehabilitation Basics, the Rehab Act as amended by WIOA. Next slide, please. As some background, Title I of the 1973 Rehabilitation Act, as amended in 2014 by the Workforce Innovation and Opportunity Act, includes the statutory framework for vocational rehabilitation or VR services for people with disabilities. Under the Rehab Act, VR services are state-provided supports and services designated to help people with disabilities prepare for, obtain, keep, regain, or advance in competitive integrated employment. A quick side note here. Competitive integrated employment is a work environment where people with disabilities work alongside of people without disabilities, earn at least minimum wage, and receive the same benefits and have equal opportunities for career development. Next slide. Here is a sample of what Congress said in the beginning of the Act as amended in 2014 by WIOA. Disability is a natural part of the human experience and in no way diminishes the rights of individuals to live independently, enjoy self-determination, make choices, contribute to society, pursue meaningful careers, and enjoy full inclusion and integration into society. Increased employment of individuals with disabilities can be achieved through services provided under the VR program established in the Act, which provide meaningful and effective participation in the workforce. This last bullet is especially powerful. The goals of the nation properly include the goal of providing people with disabilities with the tools necessary to make informed choices and decisions, achieve quality of opportunity, full inclusion and integration in society, employment, independent living, and economic and social self-sufficiency. Next slide, please. Two important areas of focus of the 2014 WIOA amendments. First, the amendments emphasize the goal to maximize opportunities for people with significant disabilities for competitive integrated employment. Secondly, the amendments codify a long history of encouraging state VR agencies to provide advanced training. Services now explicitly include advanced training for qualified individuals to pursue training for high-demand, high-wage jobs, including STEM, medicine, healthcare, business, and law. We'll be talking more about this in the later section on college and graduate school tuition. Important to also note here is this list is specifically not exhaustive of advanced training fields. Next slide. The Rehabilitation Act allows states to designate two agencies to provide statewide VR services. One that provides services to recipients who are blind, and the other that provides services to all other eligible recipients. New Jersey delivers VR services through two agencies. The Division of Rehabilitation Services, or otherwise known as DVRS, located in the Department of Labor and Workforce Development, is the larger agency that services most VR-eligible recipients. The other agency, the Commission for the Blind and Visually Impaired, located in the Department of Human Services, serves individuals who are blind, deafblind, or visually impaired. The Rehab Act, as amended, also establishes two other entities that are critically important to people with disabilities who may be qualified to receive services through either DVRS or CBVI. First, the State Rehabilitation Councils for DVRS and CBVI. The purpose of the SRCs is to review, evaluate, and advise VR agencies regarding performance and effectiveness in delivering services, with a focus of achievement of employment outcomes. Each SRC holds quarterly meetings per year, which are open to the public. Disability Rights New Jersey is a statutory member of the SRCs, and we really encourage people to attend those meetings. Meeting dates and times can be found on the DVRS and CBVI website. Second, the Client Assistance Program, known as CAP. The purpose of CAP is to advise applicants and recipients of their rights to services and benefits under the Rehab Act as amended by WIOA, as well as Title I of the Americans with Disabilities Act, the ADA. The CAP provides legal advocacy and representation to VR applicants and recipients regarding VR services. Disability Rights New Jersey is the designated client assistance program for New Jersey. Next slide, please. For the next several slides, we will cover a high-level overview of VR eligibility and process to access VR services. One pathway into VR services is through a referral of an individual with a disability from an agency, parent, or even a self-referral. DVRS has an online referral form to begin the process. For CBVI, the website includes a telephone number and email address to begin the process. The Rehab Act requires that the VR agency develop standards for prompt and equitable handling of referrals, as well as timelines for making good faith efforts to inform individuals referred of application requirements, including information and documentation necessary. CVRS recently reported that the time between a referral and an application appointment with a VR counselor is typically 1 week. The application process begins with a completed and signed application form. The WIOA amendments to the Rehab Act require VR agencies to make a common form of application available at local VR offices. However, the full application process includes the following: completing and signing the form, providing the VR agency with information necessary to initiate an assessment to determine eligibility, and the individual must be available to complete the assessment process, which could include evaluation by way of example. Generally, eligibility determinations must be made within 60 days. Next slide, please. The eligibility criteria for VR services under the Act provides as follows. An individual is eligible for services if the individual, 1, has undergone an assessment and as a result has been determined to be an individual with a disability, and 2, requires VR services to prepare for, secure, retain, advance in, or regain employment that is consistent with the strengths, resources, priorities, concerns, abilities, capabilities, interests, and informed choice. There are many details to the eligibility process, and in a few slides, I'm going to point you to other resources on our website, but a couple of quick important points here about eligibility. First, any applicant for VR services who are eligible for supplemental security income, or known as SSI, or Social Security Disability Insurance, known as SSDI, is presumed eligible for VR services. Second, prior to any determination of ineligibility, then an applicant is unable to benefit from VR services because of the severity of the person's disability. The VR agency must conduct an exploration of the person's abilities and capabilities, including trial work experience. Finally, where the VR agency determines that an applicant is ineligible for VR services, or determines that someone currently receiving services is no longer eligible, the VR agency must inform the applicant in writing using appropriate modes of communication consistent with informed choice of the determination, including reasons for the determination and the means to contest that decision. Susan shortly will talk more about the appeal rights at the end of this webinar. Next slide, please. The next step is to develop what's called the Individualized Plan for Employment, or IPE. While IPEs are generally developed in collaboration with a VR agency counselor, it's interesting to note that the Act provides the option to the eligible person that they may develop all or part of their IPE without assistance from the VR agency, or with assistance from a qualified individual who is not employed by the VR agency, or assistance from a disability advocacy organization. In addition to an employment goal, the IPE must also include the appropriate VR services, provider, and cost of services, if any, needed to achieve the goal. The IPE should be developed as soon as possible, but no later than 90 days after the date the individual was determined eligible for VR services. IPEs are reviewed at least annually, and note they can be amended. An IPE must be agreed to and signed by the recipient of services and approved and signed by the VR agent. The Rehab Act, as amended by WIOA, provides an array of services that must be made available by the VR agency. Here's an example of those services: pre-employment transition services, assessments for determining eligibility and VR needs, counseling, referral to other agencies, vocational and other training services, including support for college, graduate school, and other advanced training in STEM, medicine, law, and business, transportation, interpreter and reader services, supported employment, personal care assistance, and customized employment, and more. As we've seen, informed choice is emphasized throughout the Rehab Act as amended by WIOA and is a key component in the development of the individualized plan for employment. Federal law mandates that the VR agency must develop written policies and procedures to enable an applicant or recipient to exercise informed choice. Policies that must be developed in consultation with the SRC. The VR agency policies regarding informed consent must include the following: information about the opportunity to exercise informed choice, including support services for individuals with cognitive or other disabilities who require assistance to exercise informed choice, ensuring recipients have meaningful choice among methods to obtain services, assisting eligible individuals in acquiring information that enables them to exercise informed choice in the development of their IPE, and assisting recipients to acquire information needed to make informed choices about specific VR services, including the providers of such services, costs, and more. We cannot emphasize enough the importance of robust opportunities for recipients to exercise informed choice, especially in the IPE development process. We'll be talking more about this as it relates to financial sponsorship of college and graduate school shortly. Next slide. VR agencies must develop and maintain written policies regarding the nature and scope of all VR services and the criteria under which each service is provided. The written policies may not establish an arbitrary limitation on VR services provided to the recipient to achieve an employment goal. These policies must include the following. While there may be a preference for in-state services, that preference cannot effectively deny a service, nor can they effectively prohibit out-of-state services. Note, if a recipient chooses an out-of-state service at a higher cost than the in-state service, assuming that the in-state service would meet the individual's rehab needs, the recipient may be responsible for the additional cost. Next, the VR agency must have written policies regarding the rates of payment for all VR services. While the state may establish a reasonable fee schedule, it cannot be so low as to effectively deny services. Next, the VR agency must permit exceptions to written policies so that individual needs can be addressed. DVRS and CBVI call this the waiver process. Finally, the VR agency may also establish reasonable time periods for the provision of services. Related to the reasonable fee schedule, the VR agency must determine whether there are comparable benefits available to under other programs, and certain comparable services would not be covered under the VR agency. I will discuss these services in the context of higher education and tuition in a few slides. Financial participation by recipients. While there is no federal requirement that the financial needs of recipients be considered, VR agencies may choose to consider financial need for the purpose of determining a recipient's share of costs. There must be written policies if a state opts for consideration of financial need. New Jersey has chosen to assess financial need and participation by VR recipients. Certain services may not be subject to the financial needs test or participation, including the assessment for eligibility, VR counseling and guidance, and job-related services by way of example. Important to note here, the VR agency may not apply a financial needs test or require financial participation if the recipient is receiving SSI or SSDI. Next slide, please. You can find additional resources regarding eligibility for VR services and the process to acquire services on our website. Here is the link in which to do that. Next slide, please. The federal law, what the Rehab Act as amended by WIOA says about financial sponsorship for college tuition. Next slide, please. I will review the federal law around financial sponsorship of college and graduate school costs by VR agencies. Then I will pass the baton to Susan, who will speak more specifically about New Jersey law, including state VR policy for college tuition. I will cover the following areas. how WIOA changed the federal landscape for those seeking college or graduate school sponsorship as part of the IPE and employment goal, the 2014 WIOA amendments and their emphasis on STEM careers, setting goals for employment that include college and graduate school sponsorship, reasonable fee schedules and comparable benefits, and financial participation, including rules for SSI and SSDI recipients. Again, throughout this webinar will be an emphasis on the centrality and importance of informed choice. It is worth noting that informed choice is not just a feel-good phrase. It is a legal right, and one that should impact every aspect of the VR process. Next slide. So why is WIOA so important generally? And more specifically, how does it impact college tuition costs for VR recipients? WIOA reshaped how people with disabilities access education and training through VR agencies by treating post-secondary education as a bridge to economic mobility. The Rehab Act, as amended by WIOA, authorizes state vocational rehab agencies to provide financial sponsorship for college tuition for post-secondary and graduate level education. WIOA enhances this by strengthening the focus on competitive integrated employment, CIE, and as mentioned earlier, prioritizes people with the most significant disabilities to gain access to competitive integrated employment. WIOA matters for students with disabilities who are looking for support for post-secondary education. The Act provides the basis for eligible students to have their tuition paid for at both college and graduate school when an individual meets certain eligibility criteria. As will be discussed shortly, VR agencies through WIOA can cover tuition, books, supplies, and other fees, which can dramatically increase the likelihood that a student with a disability, including a significant disability, gets a college or graduate school degree, which leads to expanded career opportunities. And another reminder, this should all be thought of again through the context of informed choice, meaning you, the client, choose the employment goal based on full and accessible information from your VR agency or VR counselor. Next slide, please. As mentioned earlier, there's a long history of RSA encouraging VR agencies to provide advanced training when appropriate to help individuals achieve their employment goals. So employment is not just limited to entry-level jobs for those with the ability to pursue professional careers. Under WIOA, funding for advanced degrees should be available when necessary for the individual's employment goals and consistent with their abilities. This is applicable whether an individual seeks an advanced degree at the outset or initially chooses an undergraduate degree and then decides to seek an advanced degree in their career. The Rehab Act, as amended, permits VR agencies to provide VR services that encourage qualified individuals to pursue advanced training in STEM fields, medicine, law, or business. In today's fast-changing economy, it is critical for VR agencies to assist individuals with disabilities compete for high-paying careers in science, technology, engineering, math, STEM, green industries, critical infrastructure fields, and other expanding industries. That said, while certain fields are mentioned, the comments in the Federal Register, a publication of federal regulations and proposed rules, it is clear that advanced training can be provided in any field, not just limited to the ones that I mentioned. Next slide, please. As mentioned earlier, the creation of the IPE is a vital part of the VR process. The IPE must be reviewed at least annually and, if necessary, amended if there are substantive changes that need to be made. The IPE must state a specific vocational goal that realistically requires the college program for which you are asking the VR agency to pay. If the recipient is seeking funding from the VR agency for an advanced level employment goal, it is important that the IPE include the goal and training necessary to achieve that goal, and not an interim employment goal. As an example, if your employment goal is to become an attorney, You do not first need to list as an employment goal becoming a paralegal. But also please remember, you do have the ability to change your IPE. As mentioned earlier, this document is a living, breathing document. So you can come back to it and do a revised IPE if you decide to attend graduate school to meet your career goals. Again, an individual must have an employment goal that requires post-secondary education. The VR agency will consider paying for college only if the IPE clearly shows that a college degree is connected to your employment goal. Next slide, please. We have mentioned informed choice several times already this morning. In fact, informed choice is so important that Disability Rights New Jersey will be presenting a webinar entirely dedicated to informed choice, including what informed choice means and how it's implemented throughout the VR process and why it's so important. This webinar will be held live on May 21st, so later this week, and will also be taped and made available on our website. The concept of informed choice in the VR process is foundational to person-centered service delivery. Informed choice is a right, your right to make meaningful, self-directed decisions about employment goals, services, and settings. Informed choice means that an individual with a disability is an active partner in the process, who directs the decisions in the VR process. Informed choice and the IPE go hand in hand. The IPE must be developed and implemented in a manner that gives eligible individuals the opportunity to exercise informed choice, including the following: in the employment outcome, including the employment setting, the specific vocational rehab services needed to achieve the employment outcome, including the settings in which services will be provided, and the entity or entities that will provide vocational rehab services. Next slide, please. Now we will turn our attention to the federal law and the reasonable fee schedule, as those schedules relate to college or graduate school education post-WIOA. Federal law does not require one national dollar amount for college or graduate school costs. Instead, a VR agency may use a fee schedule that is reasonable. States can set rates, but those rates cannot function as an absolute cap or effectively deny an individual the education needed to achieve their vocational goal. Specifically, the regulation states that fees cannot be so high as to effectively deny service. A reasonable fee schedule must take into consideration the breadth of programs, especially graduate and professional programs, as well as different tuition and fee schedules that attach to those programs. Related, states must establish and maintain written policies that govern the rates of payment for all VR services, including the process for exceptions to those services, those rates available to individuals. In New Jersey, exceptions are called waivers. Susan will talk more about what this means for clients in New Jersey receiving services from DVRS and CBVI. The exceptions process as related to the reasonable fee schedule could be used by way of example for a quote unique out-of-school school. So think of Gallaudet or University of Rochester Institute of Technology for students who are deaf or hard of hearing. As WIOA made clear, the federal law distinguishes among graduate school services, including but not limited to STEM fields, medicine, law, and business. Accordingly, a reasonable fee schedule must provide for each distinct advanced training service. A reasonable fee schedule for law school tuition is not the equivalent of a reasonable fee schedule for an advanced humanities degree. At Disability Rights New Jersey, after looking at reasonable fee schedules in many states, we believe that the flagship state university here in New Jersey, generally Rutgers, should be the model for the reasonable fee schedule. Next slide, please. The federal regulation requires VR agencies to use comparable benefits before spending federal VR funds on tuition. Comparable benefits are services and benefits that are provided or paid for in whole or part by other federal, state, or local public agencies, by health insurance or employee benefits. These benefits are available to the individual at the time needed to ensure the progress of the individual towards achieving employment outcomes in the individual's plan for employment, and they're commensurate to the services that the individual would otherwise receive from the designated state vocational rehab agency. For the purpose of this definition, comparable benefits and services do not include awards and scholarships based on merit, nor do they include student loans. VR agencies are required to check whether other funding sources are available to provide these benefits prior to funding a specific service. In practice, that means that the FAFSA aid grants, scholarships, or other education funding may reduce what DVRS or CBVI pays if those benefits are available when needed. The regulation also says that the agency must use those comparable benefits to cover the cost of VR services when they are available, rather than duplicating funding. This is why tuition sponsorship is often treated as a last dollar of the coordinated funding process. Susan shortly will talk more about comparable benefits and student loans during her part of the presentation. Next slide, please. States do not have to consider the financial need of VR recipients or require the financial participation towards college and graduate school tuition and related costs, but they can, and New Jersey does. This means that for students under the age of 22, parental income and resources will count towards the student's financial participation. This is generally determined through the completion of the FAFSA for each year. For individuals 22 years of age or older on January 1st of the year services are scheduled, only personal income or spouse's income is to be considered. Remember, certain VR agencies are exempt from financial needs tests and cost participation. For example, expenses related to attending college, like personal assistance services, or auxiliary aid or services like interpreter services. Most importantly, states may not conduct a financial needs test or require financial participation for recipients who are eligible for SSI or SSDI. This means that VR agencies may not even request that an SSI or SSDI recipient or their parent complete a financial needs test. This is important to remember. During the IPE development process, VR agencies must inform an individual of the applicable agency guidelines and criteria for determining the eligible individual's financial commitment under the IPE, including informing individuals eligible for SSI or SSDI benefits that they are not responsible for the cost, and this must be included in the IPE. On a policy note, financial needs tests and policies that require participation in the cost of VR services may disincentivize individuals from participating in the VR program, thereby hampering their ability to achieve competitive integrated employment and reduce reliance on public benefits. Lastly, so what is covered by VR agencies? Most state VR agencies cover tuition and mandatory fees for college, which includes required course materials and textbooks and standard supplies for your courses. So think of items necessary to complete your coursework. In some circumstances, they will also cover room and board. Thank you so much. I would now like to turn your attention to Susan Head to talk more about New Jersey State VR agency laws and regulations. Thanks, Sue.
DVRS and CBVI financial sponsorship for college tuition. Good morning. My name is Susan Head, and I'm a senior advocate and coordinator of the Client Assistance Program at Disability Rights New Jersey. As Stacy explained, the purpose of the Client Assistance Program, or CAP, is to provide advice, legal advocacy, and representation to applicants and recipients concerning access to individualized vocational rehabilitation services. In New Jersey, we have two VR agencies, the Division of Vocational Rehabilitation Services, or DVRS, which is the general VR agency serving individuals with mental, physical, and cognitive disabilities, and the Commission for the Blind and Visually Impaired, or CBVI, which is the agency serving individuals with visual impairment and blindness. The federal regulations require that state VR agencies have written policies covering the type and scope of services they provide. However, The regulations are explicit in stating that state policies may not establish arbitrary limits on the services to be provided. As an example, a state VR agency can establish a preference for in-state services, but they cannot have policies that effectively prohibit out-of-state services. Stacey gave an example earlier of a recipient who is deaf who wanted to go to Gallaudet University. In this example, the VR agency must consider and meet the recipient's individualized vocational rehabilitation needs. Next slide. DVRS has a case services policy manual dated June 2021, which is now posted on our website in the Self-Advocacy Resource Center under Employment and Vocational Rehabilitation Services. The link to the policy manual is on this slide. We believe this manual may be updated in the near future and include DVRS's revised college tuition fee schedule, which was increased in 2023. As the slide indicates, the DVR policy manual includes language that supports post-secondary education, including support for advanced level post-secondary education. However, in our practice, we encounter many VR recipients who were denied advanced training goals. In these cases, the VR agency typically recommended a less advanced goal and informed the recipient they would revisit the advanced goal after the recipient had completed an interim academic credential or worked in a related field for a period of time. An example of this issue would be if a qualified recipient wanted to go to law school, but the VR agency recommended the recipient pursue a paralegal training. In this example, the VR agency may advise the recipient that after completing the paralegal training, they could amend the IPE to include support for law school. However, while the federal regulations make clear that VR agencies should assist individuals advance in employment, without a signed IPE documenting the advanced career goal, there is no guarantee the VR agency would support the advanced goal at a later date. In this scenario, the recipient would need to decide whether to accept the VR offer to pursue a paralegal training in lieu of law school or appeal the decision. We'll discuss how to appeal VR decisions shortly. Next slide, please. 3 years ago, following advocacy by Disability Rights New Jersey, DVR increased their fee schedule and aligned the fee schedule with the published rates for New Jersey's flagship state university, Rutgers, at the in-state resident rate for tuition and fees. The fee schedule includes the costs for each designated major, both at the undergraduate and graduate level, including but not limited to advanced degrees in the STEM programs, as well as medical, business, and law degrees. Prior to this revision, DVR only funded a fixed amount for graduate degrees, regardless of the discipline. Before DVR changed their funding policy, an individual seeking financial sponsorship to pursue, for example, pharmacy, would have only received funding at a flat rate, regardless of the discipline. Now, if DVR approves an employment goal like pharmacist, assuming the individual is financially eligible for cost services based on the financial needs assessment or receipt of Social Security benefits, DVR will fund the associated costs for the pharmacy degree. By contrast, CBVI has a different method for determining their fee schedule, which we would argue is less favorable because it does not distinguish between graduate disciplines. Next slide. Here's the current DVR fee schedule for full-time students. As the slide indicates, the maximum amount that DVR may contribute to the cost of tuition and fees for any college or university in or out of state is the current published Rutgers University rate. Funding for room and board is up to $7,500 per semester. DVR will only pay room and board costs if the student lives more than 50 miles away from the school. However, as the DVR policy manual indicates, DVR will consider exceptions to this policy based on individual circumstances, including disability, mode of travel, need for assistance to travel, class schedule, etc. Next slide, please. And here's the DVR fee schedule for part-time students, which, as the slide indicates, is the current published per credit tuition and fees rate at Rutgers University. Both DVRS and CBVI indicate preference in their policy manuals for recipients to pursue full-time attendance at college. Recipients seeking DVR funding to pursue a part-time schedule will need to justify why they can only pursue a part-time schedule, which may be related to the person's disability or other unique circumstances. Next slide. The provision of VR services by CBVI, like DVRS, is governed by federal regulations. Like DVRS, CBVI has a policy manual specifying how services are to be provided to eligible individuals. We've posted the 2024-2025 version of this handbook on our website in the Self-Advocacy Resource Center and included a link to the handbook on this slide. CBVI have confirmed that the 2024-2025 version of the handbook remained in effect for the 2025-2026 school year, and they're in the process of drafting the 2026-2027 version of the handbook. To receive CBVI funding for post-secondary education, recipients must be accepted into an accredited full-time college program and pursue 12 credits for undergraduate and 9 credits for graduate programs to be considered full-time. Recipients seeking an exception to this policy must submit a waiver of the policy every year. Both VR agencies have a waiver or exception process, which can be requested when the agency's policy does not meet the recipient's individualized needs. In the context of the CBVI policy requiring college students to pursue a full-time schedule, the recipient may need to request a waiver of this policy based on any number of factors, including their disability, family circumstances, travel limitations, etc. When a recipient requests a waiver, the VR agency may request written justification to support the request, which could include a doctor's letter or other information explaining the reason for the waiver request. Next slide. CBVI provides a range of services to eligible individuals, including VR services. Within the VR program, CBVI has a separate unit for individuals wishing to pursue post-secondary education. Recipients accepted into CBVI's college unit are assigned to a VR college counselor and provided with a copy of the Guide to College Services Handbook. The handbook indicates that CBVI provides support for graduate degrees, but does not specifically include language indicating that CBVI will provide financial support for advanced degrees. The handbook also indicates that employment goals requiring degrees above a bachelor's degree are subject to a decision based on the College Services Graduate Studies Procedure number 03. We don't have a copy of this policy. However, recipients may request that CBVI provide them with a copy of the policy. It's important to note that while state VR agencies are permitted to have written policies governing how they provide services, as Stacey explained, the Rehabilitation Act, as amended by WIOA, requires that state VR agencies encourage qualified individuals to pursue advanced training goals. As the slide also indicates, High school students with visual impairment or blindness with plans to attend college may want to contact CBVI as early as possible during transition planning so that eligibility for CBVI services can be established and they can learn about CBVI's college unit policies and procedures. Next slide. CBVI's fee schedule, which we'll highlight in the next few slides, is based on the 2024-2025 version of their college handbook. The current methodology used by CBVI to determine their college fee schedule is based on the average costs of the medium public four-year state colleges and universities in New Jersey. We respectfully disagree with CBVI's methodology for establishing their fee schedule, especially for graduate degrees, as unlike DVRS's fee schedule, which uses Rutgers University's published rates for graduate degrees, CBVI's fee schedule does not address the published costs for certain STEM programs and advanced degrees in medicine, business, and law. In other words, as things stand, a qualified CBVI recipient wishing to pursue a career as a pharmacist or lawyer, for example, would receive the same funding as a recipient wanting to pursue a graduate degree in education, despite the fact that this degree would cost significantly less than a law or pharmacy degree. Next slide. Here's CBVI's current fee schedule for undergraduate degrees. As the slide indicates, CBVI will fund $7,877.50 per semester for tuition and fees for full-time students and $485.65 per credit for part-time students. CBVI provides $7,881.25 per semester for room and board charges. CBVI provides other funding for books and supplies, transportation, reader, and other services outlined on this slide and in the college handbook. Next slide. And here's the current fee schedule for graduate degrees. As the slide indicates, CBVI will fund $884.41 per credit for tuition and fees, excuse me, and $7,881.25 for room and board charges each semester. Next slide. Here are common barriers recipients seeking access to VR funding for college and advanced degrees may experience. A major barrier for VR recipients is a presumption by the VR agency that they should pursue a less advanced employment goal. For example, certified nurse's aide over licensed aide. In addition, when the VR agency's fee schedule is too low, a recipient may not be able to afford to pursue an advanced degree when federal grants are not available. Recipients are frequently not informed by the VR agency that they can request what the New Jersey VR agencies call a waiver or exception, using the federal language, of a policy that may be necessary for any number of reasons, including financial need. In addition, delays in receiving equipment, services, or accommodation can be a significant barrier to the recipient obtaining the necessary funding and support to pursue an advanced career goal. Next slide, please. Student loans are not a comparable benefit. However, as this slide indicates, both VR agencies may consider student loans in the financial analysis of the cost of college if the recipient applies for student loans on the FAFSA form. There may be circumstances when the recipient needs to apply for loans. For example, if there is a delay in receipt of VR funding at the start of a semester. However, to reduce the need to take out student loans, we recommend the recipient engage with the VR agency on this issue prior to completing the FAFSA form to determine whether it is necessary to apply for student loans as an eligible VR recipient. In cases where a VR recipient takes a student loan, it is important to fully understand the financial consequences of taking more than the reasonable fee schedule, absent a waiver. And to the extent a financial needs test and policies require participation in the cost of VR services, this may disincentivize individuals from participating in the VR program, thereby hampering their ability to achieve competitive integrated employment and reduce reliance on public benefits. Next slide. So here we have your rights to statutory due process. This will be the final topic of the webinar, and we are going to discuss due process rights under the Rehabilitation Act as amended by WIOA. These rights are statutory, and while comprehensive and strong, they are not constitutional rights like those afforded Medicaid recipients. When I say due process, it may be easier to think administrative fair hearing. Next slide. Statutory due process or appeal rights means that the government must act fairly and follow certain procedures, like written notice and an opportunity for a hearing, before taking adverse action against an applicant or recipient of VR services. Under the Rehab Act, as amended by WIOA, VR applicants and recipients who are dissatisfied with a VR agency determination that affects the provision of services have several important statutory due process rights, which we'll discuss in turn. The right to receive written notice at key points in the VR process, including denial of VR eligibility and termination of services as examples. The right to appeal an agency's determination through both informal and formal channels. And the right to appeal a final agency decision to the New Jersey Supreme Court, Superior Court, Appellate Division, or Federal Court. Next slide. When does an applicant for VR services or a recipient of VR services have due process rights? An applicant for VR services and a recipient of VR services have the right to receive written notice and access the appeals process when, first, they apply for VR services. Note, the Rehab Act, as amended, is clear that when the VR agency determines that an applicant is ineligible for VR services or that a recipient is no longer eligible, the VR agency must inform that individual in writing of the ineligibility determination, including the reasons for the determinations, as well as the appeals process to challenge the denial. Second, they are assigned to the state's order of selection. Note there is an asterisk because we do not have an order of selection currently in New Jersey. Third, when an individualized plan for employment, or IPE, is developed. Note, while the statutory language does not specifically say that a person has a right to due process when a DVRS service is denied, an IPE that does not include a requested service is in fact a denial. And since due process rights are triggered by the development of an IPE, this is the appropriate time for a recipient to appeal the denial of a requested service. And lastly, whenever VR services are reduced, suspended, or terminated. Next slide. Federal law requires the state VR agencies provide written notice to VR applicants and service recipients of the following: the right to appeal an agency determination through an impartial due process hearing, more commonly called a fair hearing in New Jersey's administrative courts. The right to request mediation. Important to note here, neither DVRS or CBVI currently have a working mediation mechanism. So mediation, though required by the federal law, is not an option for VR applicants or recipients at the present time. The names and addresses to file a request for mediation or a fair hearing, the manner in which a mediator or impartial hearing officer, what we call an administrative law judge, will be selected, and information about the client assistance program. If the VR agency has an informal process for resolving an appeal, written notice should include information about accessing that process. Important to note that the informal process must not be used to deny an impartial hearing or mediation. And if the informal process is not successful in resolving the dispute, the VR applicant or recipient must have access to the formal hearing process, and it must be conducted within the period specified under federal law. Next slide. The federal law also makes clear that in most circumstances, a VR agency may not begin a suspension, reduction, or termination of VR services, including evaluations or assessments for eligibility or development of the IPE, pending a resolution of the administrative fair hearing. Next slide. We turn next to the 3 appeals processes. First, informal dispute resolution. Federal law permits but does not require an informal process. Important to note that where an informal process is offered, the formal fair hearing must still occur in the regular statutory time if the informal process is not successful. Both DVR and CBVI offer the informal process. Next slide. Impartial due process hearing. Both CBVI and Both DVRS and CBVI use New Jersey's administrative fair hearing to meet this federal requirement. The hearing must be held within 60 days of the applicant or recipient's request for the hearing. Next slide. At the fair hearing, applicants or recipients have the right to present evidence in support of their position, the right to present witnesses as well as examine all witnesses, and the right to be represented by counsel, including by Disability Rights New Jersey's CAP program. Next slide. Under federal law, the ALJ's decision is final unless the state has established procedures, preferably by regulation, to seek review of the head of the designated state agency, the Department of Labor for DVRS or the Department of Human Services for CBVI, or an official from the governor's office. There is a bit of confusion about this in New Jersey right now because of a very old expired regulation. So if you disagree with the ALJ's decision, it may be handled one way by DVRS as a final agency decision and another way by CBVI as an initial agency decision subject to review. Regardless, an applicant or recipient always has the right to appeal an adverse decision to the New Jersey Appellate Division of the District Court of New Jersey. You can find more information about the appeals process on our website, the same link that was provided above. This concludes our presentation. If you have any questions, please put them in the chat box or raise your hand.
Well, thank you, Susan and Stacy, so much. That was outstanding, and that was a lot of information. We didn't actually get questions in the chat other than how to get a copy of the presentation, and we do send out a copy of the presentation to everybody who signed up for the webinar after the webinar, and it will also be available on our website, the slides, and what we have also been doing, both the presentation, the slides, and we've also been putting the transcript there so people can actually, it's searchable, can see and go back and review without necessarily listening to the entire presentation. We are up on the hour just now, so I think we're happy to stay for a few more minutes. If anybody wanted to put a question, please actually don't raise your hand. put the question in the chat box. But also we understand that this webinar was over at 11. So if you need to leave to get to your next meeting, please do. Otherwise, I'm just looking for another second to see if there are any questions. I'm not seeing any. So again, a huge thank you to Stacy and Susan for an excellent presentation. And I saw the thing, a lot to digest. I agree, it is a lot to digest. Please take the time to do that. And I just one last plug. We're having a webinar on Thursday on informed consent that Stacy and Susan are also doing. So please sign up for that webinar as well. And everybody have a great day. Thank you so much.
Thank you so much.